before we start the formal part of the meeting, I just want to advise the committee. So I became chair of this committee in December, as you all recall, or late November, when Minister Miller had to relinquish this seat when he was reappointed to cabinet. I was asked to take on this role on an interim basis. I have a different interpretation than interim than apparently the people that asked me. But one thing led to another, so I've been here for 6 months now, but I'm stepping down as chair effective immediately. I'm going to turn it over to the clerk in a moment so we can proceed to the election of a new chair, but I just want to say thank you to all of the members of the committee. We've had some interesting discussions. We've had some long discussions, but I can honestly say I've enjoyed almost every single minute of it. And I enjoy working with every single one of you, although we all share differences at times, but it's been a functional, highly functional committee, and I just want to say thank you to everybody here, and I appreciate it. And I'm not going anywhere. I was sitting over there instead of sitting here. So. Yeah, no, don't read anything into it. No. I'll be sitting over there, Andrew. Don't worry. Anyway, I just want to say thank you, and I thought, in fairness to Ms. Lapointe, who's here today, we're going to start a bill. I thought we'd do that at the outset and proceed to the election of a chair, and then we can jump right in. So, but and the last thing I would like to say is I want to say a huge thanks to the people who sit to my left and to my right, because nobody can sit in this chair and do the job at all without their help and all the other people in the room. So thank you very, 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 very much.
Chair, if I may. That I've never challenged your decision. I am almost on the edge of my chair wanting to do that. But just a few words. I think I speak on behalf of all members of this committee to say thank you. You've done an outstanding job steering this committee, and we very much appreciated your chairmanship. Thank you again.
Thank you. I appreciate it. All right. Over to you, Mr.
Monsieur le Président, si vous le permettez, je veux joindre ma voix.
If you allow me, I'd like to join my voice to that of my colleague Patricia to tell you that I haven't always agreed with your decisions. We have a number of disagreements, but your interventions have always been authoritarian, well, not authoritarian, but made with authority and with huge respect, and that's something that I highly appreciated, the respect that was the tone of your decisions every time, and I really want to thank you for these 6 months of chairmanship. It doesn't mean that we agree on many issues, but I really appreciate your decisions, and I thank you.
Okay, thank you, because we want to get to Ms. Lapointe. So that's my final ruling as I'm moving over there.
Thank you, Mr. Chair, for the kind words. I'm requested to see a quorum. Obviously, I see one. So, pursuant to Standing Order 106.3, as the clerk of the committee, I will preside over the election of the chair, the new chair. I must inform members that the clerk of the committee can only receive motions for the election of the chair, cannot receive other types of motion, cannot entertain points of order, nor participate in debate, of course. Nous pouvons donc maintenant procéder à l'élection de la présidence.
Cannot proceed to electing the chair pursuant to Article 106.2 of the rule. The chair must be a member of the government party.
I would like to nominate as the new chair Member of Parliament Ikra Khalid.
Okay.
Thank you.
That's it. Yeah.
Thank you. Are there any other nominations? Seeing none, I would declare Madame Khalid chair of the committee. Thank you. Welcome. Yes. Thank you.
Good luck, Ikra.
Be kind, okay? Thank you.
Okay. I feel you are used to this script that we read at the very beginning.
Good afternoon, everyone. First off, I will just say thank you so much, MP James Maloney, for your phenomenal job as Chair for Justice. You have really shepherded us through a lot of important legislation and through really, really important studies. We really appreciate the work that you've done. So I have really, really big shoes to fill. I really appreciate the work that you've done. Can we please acknowledge him and recognize the amazing work that he's done? I'm very, very humbled to be in this position now, and I would like to go on to Madame Viviane Lapointe for her opening remarks on this bill. Madame Lapointe, you have 5 minutes. Please go ahead.
Merci, Madame la Présidente, et félicitations. And thank you to the members of the committee.
Et merci aux membres du comité de m'avoir donné l'occasion de parler.
Because of the conversations I've had with people on the front lines of the opioid crisis, human trafficking, addiction, homelessness, and community safety. À Sudbury, comme dans de nombreuses régions du Canada, nous avons
In Sudbury, such as many regions of Canada, we've been witness to the tragic effects of drug trafficking and human trafficking had on individuals, families, and whole communities.
people to addiction. We've seen vulnerable people exploited and victimized. We've seen families struggling to find help for loved ones. And we've seen frontline organizations stepping up every day to support these people that are in crisis, often with limited resources and we know with growing demand. Across my community, I've met with shelters, recovery organizations, victim services, outreach workers, police, and also municipal leaders. The message I hear is remarkably consistent. Communities are carrying enormous costs associated with these crimes, and many of those costs are being absorbed at organizations that we know are already stretched thin. When a drug trafficking network operates in a community or when someone is exploited through human trafficking, the harm doesn't end when a police investigation is complete or when charges are laid. Victims need support, families need support, people struggling with addiction need support, communities need support. And very often it is the local organizations that step in to provide those services. Ils répondent aux besoins des populations.
They react to the population's needs, they intervene in emergency situations and help people to rebuild their lives. If they do this, it's because they feel profoundly attached to their communities. But this work has a real cost.
Is about recognizing that reality. The bill proposes a targeted amendment to the criminal code that would allow courts and, in certain cases involving drug trafficking and human trafficking offenses, to consider restitution for eligible community organizations that can demonstrate measurable costs resulting from those crimes. Importantly, this bill does not create a mandatory penalty. It does not replace restitution for individual victims. It does not remove judicial discretion. Instead, it provides courts with an additional tool they may choose to use when the facts or a case support it. The bill provides clarity and certainty, and in doing so, it addresses a gap in the current framework where courts have not always had clear legislative direction regarding restitution for organizations that incur costs responding to the impacts of these crimes. At its heart, this bill is about accountability. When serious criminal activity causes harm, there are costs. Some are borne by victims and their families, some are borne by municipalities, and some are borne by the organizations that step in to help pick up the pieces. Je pense que nos tribunaux devraient.
I think that our courts should be able to take into account these costs when they can be easily ascertainable.
Crisis. It is not a complete solution to human trafficking. Those challenges require action on many fronts. But it is a practical step that recognizes the work being done every day by organizations that support victims, strengthen communities, and help people recover from the impacts of crime. Let's all be mindful that acknowledging the harm done to communities and providing reparations for such harms are recognized objectives of sentencing under the Criminal Code. I want to thank the many organizations, community leaders, police services, and frontline workers who shared their experiences and helped shape my understanding of this issue. I look forward to your questions and to working with members of this committee as you undertake your study of the bill. Thank you. Merci.
Thank you.
Yes, Mr. Lawson, go ahead.
Thank you, Madam Chair. There have been discussions among the parties, and given the hard stop we have, I think if you seek it, you'll find unanimous consent to allow the officials to appear alongside the bill sponsor and take questions for the
Thank you.
remaining
I
hour.
appreciate that. I was actually just discussing that with our clerk. So if I can ask the officials to please come join us at the table, and we will start our questions as soon as you arrive.
An hour. Okay. I'm not sure.
Thank you. Thank you very much. Madam Joanna Wells, who is a senior counsel and team lead, criminal law policy section. Thank you very much for joining us. And then we have Alexander Goldwelski, who is counsel for criminal law policy section. Thank you very much. We'll go right into questions, as we know that the time is short and we want to make sure that everybody has the opportunity to get their questions in. We'll start with Mr. Lawton for 6 minutes. Please go ahead, sir.
Thank you very much, Madam Chair, and merci, Madame Lapointe, for being here.
And thank you, Ms. Lapointe, for being here.
New member of Parliament, but I understand getting a private member's bill even to this stage is something that is quite an accomplishment. I don't doubt your intentions. I think we've seen over the last 10 years, you and I would probably disagree on causes, but I think we've seen, just rampant criminality, and it's communities that are paying the price for this. And at the same time, I also am very mindful of policies and proposals that I fear will give false hope to communities. We know that 2% of cases involve restitution, and of those, just 1/4 of restitution orders are actually paid. So how is your bill going to actually deliver where you're effectively trying to get it to deliver?
So as we know, restitution orders exist in our judicial system today, and across all of those, the bill does not guarantee payment. What it does do, though, is it gives courts an option when there are measurable costs that can be verifiable. It provides judges at that point in time when they're about to give restitution orders an ability to recognize communities as being included in restitution. When I spoke to some legal advisors, they told me that judges actually currently have the ability to give restitutions to community. It exists, but there's very little to no definition of what compromises a community, which is why judges are reluctant to make those restitution orders towards communities. They also aren't certain on what would be appropriate costs to award. So again, this bill serves to provide some of those definitions for judges to offer them that tool.
Community organizations do valuable work on the front lines, but they are not themselves the victims of crime. So is there not a risk that by trying to ensure restitution orders are giving money to organizations, you're actually diverting, if you wanted to go the restitution route, you're diverting from victims, the people directly affected by crime?
So that was a concern that was raised when we were debating the bill in the House, and it is something that the intention of this bill is by no means to take away restitution from victims. Victims need to be considered first and foremost. And in hearing the concerns raised on the floor in the chamber, I'll be bringing forward amendments to the bills that make that even clearer in the drafted bill that I have. And I'll be bringing those amendments to the clerk, because I think that is extremely important. This isn't meant to compete, but rather to create another pathway for a judge, but not instead of, but also. It would be the intent of this bill.
If you have a finite amount of money that, let's say, could be extracted, which again I think the stats show is quite difficult, who gets the first piece of that pie, the victim or the organization?
So that will be up to a judge to determine that, and as we know, judges weigh evidence and causality in a courtroom, and that would judiciary decision-making remains with the judge, certainly, and that does not change, and this bill does not change that. I have to tell you that in speaking with victims of human trafficking, they talked about how much they rely on the services they receive in the community. And they have said that they support the idea that victims, as well as the community organizations, would both be applicable to receiving restitution.
In looking at the list that you've enumerated of the type of organizations that you believe should be eligible for this funding, under subsection 2, you have expenses to provide harm reduction programs, including overdose and infectious disease prevention programs. When you say harm reduction, are you including Safe Supply?
In the consultations that I had with service providers and frontline providers, they talked a lot about how they have to respond to overdoses right there. So the ability to respond to those overdoses was what the intention was in the wording there.
Just, the reason I ask is because Safe Supply has been an unmitigated disaster. We have seen provinces like British Columbia and Ontario that previously wanted to dabble in that, see the carnage of it. It's caused more overdoses, more criminality. If, from what you're saying, you're purely focused on overdose and infectious disease prevention, would you accept or would you support an amendment to ensure that Safe Supply programs are excluded from this?
I am here to defend my bill, but I'm defending my bill with my ears very much open, and I would welcome suggested amendments on what we could include in terms of admissible expenses.
I'm just asking, is your intention to fund Safe Supply programs or not? Because if your intention is not, I think that's a natural amendment, if that's not keeping with the spirit of what you're trying to do in that section.
I'm not an expert in the field of mental health and addictions. I'm not here to argue on the merits of a safe supply or not. I'm simply here to talk about the community organizations and the services they provide that are provided sometimes from our own hospital and healthcare systems and people working and doing social work. So.
But you don't think we should be funding things that are aggravating the problems we're trying to solve, I think is fair to say, correct?
I am here to say that the frontline organizations and first responders that provide those services to the victims of these crimes deserve to be recognized within our judicial system. Many of them have told me also that they're invisible. Right now, they are not seen in our judicial system, and this bill provides them with an ability to be measured and considered in terms of the impact of these crimes on a community.
Thank you very much. We're going to move on to Mr. Housefather for 6 minutes. Please go ahead.
Thank you very much, Madam Chair. Thank you very much, Madame Lapointe, for being here with us today, and congratulations on making it this far in the process of a private member's bill. It's a real achievement. So let me ask you, you briefly elaborated about talking to a lot of organizations, but what inspired you to come forward with this bill in particular?
I think we've all seen the devastating impacts that the opioid crisis have had on our communities, on our downtowns, and certainly after COVID. We've seen how the victims of these crimes have been impacted, as well as our municipalities who are struggling with the effects of these. We see our rates of homelessness. We see mental health and addictions at all-time highs. We continue to see opioid-related deaths. I can tell you in my community of Sudbury, we had the highest per population, per capita numbers of opioid-related deaths in Sudbury. Northern Ontario has been really impacted by this. We have a lack of resources, infrastructure that you would see in other regions. And so in seeing those devastating impacts and knowing how these organizations are still stepping in every day and our first responders are meeting the call, I felt that this was a really important time, as well as a point in terms of creating this opportunity for these first responders, for criminals to be able to be held accountable to the harm, not only to the crime, but to the harm that those crimes create to victims and to communities.
give you a chance, are there any specific organizations in your riding of Sudbury you want to call out for their good work that you would like to say that you appreciate today, and sort of how they inspired you to come forward with the bill?
Yeah, there are so many. I will highlight Go Give project as well as the organization Angels of Hope, who provide services to support services to people who have been victim of human trafficking. They actually came on the radio with me on CBC, and we all talked together about this bill.
Point d'ordre. Il y a un problème.
Point of order. There was a problem with the sound. There was no sound. I believe that when the witness was speaking, I don't know if you wanted to check again.
Check with the interpreters if
Mr. Fortin can continue to speak.
Monsieur Fortin, pourriez-vous parler?
Could you please speak French a little bit?
N'entendais pas ce que le.
I'm saying that the interpreters couldn't hear what the witness was saying. There was a technical problem. The interpreter says that the witness's microphone was not on.
Witness's microphone was not on at that time, but if there's anything that was missed by you, perhaps the witness can repeat it. That's okay?
Oui,
Try
si le
again,
micro
Madame
fonctionne.
Lapointe.
So there are many organizations that offer such important services. The two that I'll highlight is the Go Give project, who provide support services to those that are unhoused and suffering with addictions, as well as Angels of Hope, who provide services to victims of human trafficking. And they appeared on CBC with me on the radio, and where we all talked about, again, that notion of there is the restitution, but there's also the idea of all of these community organizations being invisible in our judicial system. They are not seen, and yet the impacts of those crimes and the harm that they do, they play such a large role. And so we talked about how this bill is important and is supported by them.
In terms of the comment made previously by Mr. Lawton, if we were to put forward an amendment to clarify that direct victims would be preferred over the organizations in terms of the restitution funding, how would you react to that?
I would very much be in favor of that, because this bill is by no means meant to replace the victims and to minimize the harm that victims themselves have felt and suffered through as a result of these crimes.
Perfect. And if we were, for example, to put forward an amendment that might expand the scope of the bill to reference other victims, for example, going beyond trafficking and drug offenses and adding sexual violence or intimate partner violence, would you be supportive of that?
I absolutely would be. When I tabled this bill, I kept it focused to human trafficking and to drug trafficking, because the impacts of those crimes are seen so readily in communities. But I always saw it as a first step, not the final step. And so the inclusion of intimate partner violence and other crimes of that nature would be very appropriate. In these, we know that service organizations as well offer very important services to the victims of those crimes.
Following C-16, that would be a correct step. The committee just finished with that. Madam Chair, am I done? Yeah.
You have 30 more seconds if you'd like.
Thank you very much for being here.
Thank you very much. Moving on, Monsieur Fortin pour 6 minutes.
Mr. Fortin, you have 6 minutes. Thank you, Madam Chair. I want to start by congratulating you, Madam Chair, for your election to this position. And I'm convinced that we will have good meetings and that you will know how to be very judicious in exercising your role, and also in a respectful way, and I thank you for that. Madame Lapointe, I thank you for having tabled this bill. I have to say that your concerns in terms of the support of community organizations that help victims, it's something that really concerns us at the Bloc Québécois. In Quebec, there are many organizations who come to support victims in the court cases that they have to go through after they lodge a complaint. And we know that those people need funds, and we agree. We have often asked the federal government to transfer some funds to the provinces to help them to face the needs of the organizations. So I would like to ask the officials some questions, Ms. Wells or Mr. Golgevsky, whoever can answer. But how are we going to prove those needs for restitution if there's such a request?
Merci pour la question, monsieur. I'll respond.
Thank you for the question.
The restitution provisions in the code are clear that they have to be, expenses have to be readily ascertainable. They have to be directly linked to the offense. Courts are able to hear evidence at sentencing hearings. This is when the part of the process that we would be talking about here. So there is a capacity for courts to hear evidence to prove those expenses, but really the intent of the restitution provisions is not that they should be complicated to prove. They have to be readily ascertainable, easy for the court to determine. So it'll depend on the specific expense, what that'll look like, but they're intended to be very straightforward.
Comme on sait que c'est de la nature de...
As we know that it's the nature of seeking redress, it's a bit like a civil trial. So I could imagine an organization that would say that this situation with this person cost us at least $15,000, and we're asking that amount of redress. The accused will have to say, no, it's impossible, $15,000. Maybe it's more, something like 5,000 or whatever. So there will be a debate that has to be anticipated in terms of the amount of the damages and the link of causality. You have to prove the fault, who's at fault. So I don't think that will be contested. But in terms of the amount of damages and the relationship between the infraction and the amount. So have you anticipating how much time will be necessary to debate that sort of issue?
In terms of the last part of your question, in the amount of time, it can be very fact specific to the offense that's before the court. But one thing that we haven't conducted that kind of assessment. One thing that I would say, because you raise a good point with respect to civil, the realm of civil courts, and the jurisprudence, the case law is very clear that restitution is not intended to displace civil remedies. So if there are very complex questions about the amount of damages or the responsibility of the parties, then it may be an indication that it's not the realm of restitution.
Au moment où on se parle, la charte canadienne...
As we speak, the Canadian Charter of Rights already anticipates redress for the victims. Am I mistaken? The Victims Charter Act, or Charter, Victims' Rights Act, Charter rather. Yes, I'm sorry, I missed the translation. I think I heard it's just difficult, but time is passing. So the question was, does the Canadian Charter of Victim Rights already provide for an indemnization in such cases?
The Canadian Victims' Bill of Rights and the Criminal Code do outline the right of victims to put forward a request for restitution. Yeah.
Maintenant, la Charte canadienne des droits des victimes, là, la même loi, prévoit que...
The Canadian Victims' Bill of Rights says that a definition of a victim is any person who has experienced harms. So that seems to exclude an organization. Am I mistaken?
In terms of the Canadian Victims' Bill of Rights, but what I would say is that the Criminal Code does use different language in Section 738.
Oui. Est-ce qu'à ce moment-là, vous ne seriez pas d'avis qu'il y a...
So in that case, don't you think that the Canadian Victims' Bill of Rights should have in the definition of victim not only an individual but as well a community organization or an entity, a moral person, so to speak?
It's a good question. I don't know the answer. I don't know if my colleague can speak to that. But I would say that The restitution orders under Section 738 can be about victims, but they can also be about others, and so it's possible that there could be differences between the two statutes. But I don't know if my colleague has anything to add.
Thank you. That concludes your time, Monsieur Fortin.
Merci, Madame la Présidente.
Counsel.
Et je respecte votre décision. Je vous
Thank you, Madam Chair. I respect your decision, but I'd like you to take into consideration that sometimes there are translation problems, which mean that I can lose precious seconds. But I understand, and it's fine for now. But I just wanted to make you aware of the fact that the time allowed for translation reduced the times that left for the witness to answer my question. But thank you, Madam Chair.
I would welcome the witnesses if you do have a response that you'd like to add on to the question that Monsieur Fortin proposed. If you can please send it to us in writing. We would like to deliberate on that as well. Thank you very much. Moving on to our second round for 5 minutes. Mr. Baber, please go ahead.
Thank you. Thank you very much for your attendance, MP Lapointe. I have, looking at the proposed bill, you propose for the payment of expenses to provide harm reduction programs, including overdose and infection disease prevention programs. So just to confirm, does that include safe injection sites or not?
Again, I am here to talk, and the goal of the bill is to give shape to communities and community organizations that provide supports to people of these crimes. I am not here to bear opinion on what services are deemed to be effective. I'm not a healthcare expert, but these list of services have been developed by people who are in the field, first responders, and who provide services to these victims of crime directly. And so they reflect the consultations.
I understand that you're not opining on the quality of such services, but your bill explicitly provides for restitution of expenses to provide harm reduction programs, and that includes drug injection sites. And the challenge I have is that in the very chair you're sitting in right now, we heard testimony from the Toronto Police Association, who said very, very clearly that drug injection sites increase local crime, increase neighborhood crime. Would you agree with that or not?
Again, I cannot comment on what a witness has said before this committee, but what I can tell you is that the list of services that are provided in the bill have been as a result of the consultations that I've had with people who provide these services directly to the victims of these crimes. I am not an expert in that field of healthcare or social services or addictions,
But if an
but I
institution...
respect the consultations and the input that they've had in the drafting of this bill.
But in your view, if a local institution has the effect of manifesting crime, attracting dealers, attracting gangs, causing violence, diverting supply, inviting traffickers, inviting underage persons to traffic or to solicit narcotics, then should such an institution be made a beneficiary of such a restitution order as you propose in your bill? Simple question.
Again, I will tell you that the list of appropriate expenses or eligible expenses to be considered within a judge, and again, that judicial decision-making rests with a judge. This bill does not in any way try to remove the decisions that a judge is empowered to make at that point in time when charges are laid and when restitution orders are made. And so I respect that judicial process, just like I respect the consultations that I received from the frontline providers.
You may remember a woman named Carolina Hobner-Mackart, 44-year-old mother of 3, who was hit by a stray bullet outside of the South Riverdale Community Health Center on Quinn Street East near Carlo Avenue on the 7th of July, 2023. It's a case that shook the city of Toronto, shook the entire province of Ontario, and I find it very objectionable that seemingly as a result of this bill, which I'm sure is well-intentioned, the South Riverdale Community Center, which attracted the very violence that resulted in the loss of this mother of three, could be made a beneficiary of such a restitution order. Looking at Clause 1 to the main, Subclause 1I, to the main section of your bill, you're also talking about expenses to provide emergency shelter. We all agree that there's a homelessness catastrophe after 11 years of Liberal government in our country. However, I'd like to point you to the fact that Toronto City shelters are now a standard operating procedure, hand out needles and drug accessories, and in very many instances actually perpetuate and contribute to crime within the community. So is it your view that upon the opening of a new, what we refer to as a drug den within a residential area, should such an institution that hands out needles be eligible for a restitution order, in your view? Because that's what Section I says in
A
your bill.
very, very brief answer, if that's okay, please. Thank you.
Well, through you, Chair, I will simply say that the advocacy that you are that you are making today is certainly echoed in my bill. We want to protect victims of these crimes, both drug trafficking and human trafficking crimes, and the impact that they've had. You've listed them. I can tell you that the communities in Northern Ontario have also been very much impacted by the crimes of human and drug trafficking. And this bill is meant to bring reparation to the victims as well as their families and to the organizations that provide vital supports to those victims of the crime.
Thank you very much. Moving to Ms. Gladue for 5 minutes. Please go ahead.
Thank you so much, Chair, and thank you, MP Lapointe, for being here, and congratulations on getting to the stage with your private member's bill. So I understand what you're outlining in your bill, but I have a couple of practical questions, because if the judge is the person that is going to assign a reparation to be made to an organization, I mean, how do they know which organizations would benefit? Is it something that the prosecutors will suggest, or how would they become aware of that?
So a judge would listen and weigh evidence in a case, just like they do now. Restitution orders exist within the criminal code, and they provide those, and they would make those decisions largely based on the evidence that is produced. It is very important that in terms of the organizations, the costs or the eligible costs would need to be very much verified. They would need to be credible and related to the crime of itself. So this bill is very much in keeping with the restitution process that already exists within the criminal code.
Very good. And so then it would be the responsibility of the lawyers to gather the cost information, probably the prosecution, I would think. And so I know that there was some information shared earlier about a very low percentage, 2% I think was the number of the restitution orders that are actually made. And so it makes me wonder, what is needed in order to make this a more often used tool? Is it a training thing for the lawyers? Is it training for the judges? Could you comment on that?
So while judges already have the ability to provide restitution to communities, they rarely do. And that is because communities are not well defined within the criminal code. And then there's also what would be an appropriate cost that could be allocated in a restitution. So there's a real lack of definition and guidelines for a judge to use, which is why they often won't. So what this bill attempts to do is provide those definitions within the criminal code in that section specifically, so that it can equip a judge with those tools should a case come forward where it would be deemed appropriate to order restitutions to an organization providing services to victims of these crimes.
Excellent, thank you. We're doing a study at Status of Women, and we've heard unbelievable testimony about the number of women being turned away from shelters, the number of women being human trafficked, and we heard testimony about how it's rampant everywhere, but especially in the north. And so you did give a shout out to a couple of organizations in your riding. I wonder if there are others that are involved in the shelter victim services that might benefit from this bill.
Absolutely, and there are so many that provide such important services from our hospitals, our emergency departments, our paramedics, and as well as our shelters, women's shelters, youth shelters, and they do so on very limited resources, and that is something that I heard over and over again, that their ability to be able to continue to provide these services as demands increase, which is very unfortunate, so that they are extremely stressed in terms of the resources allocation that they have. And much of their funding, is they need to resubmit for grant funding. And so this is an opportunity and another avenue for a funding opportunity for them. It's not meant to replace the responsibilities we have at both federal, provincial, and municipal governments to support these organizations, but it does allow another pathway for these services.
Thank you. And practically speaking, in terms of the funds, the court will collect the funds that are ordered, and then they're the ones that distribute them to the organization, or how do you envision that working?
Because I do want to make it clear that there isn't a new or added layer of administrative burden that is being created by this bill. Restitution orders exist within the criminal code now, and they are managed through those. This would simply continue along in that process that already exists.
Excellent. Thank you very much. I wish you the best of luck.
Thank you very much. Moving on, Monsieur Fortin, for 2.5 minutes. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chair. Earlier, I was talking to you, Ms. Wells, about these issues of the Canadian Victim Bill of Rights. So the evidence that will have to be given and what's the procedural tool that's in the Charter. Are you not afraid? Because currently the backlogs for criminal cases are much too long. There are cases that do not come to the end because they cannot be done within the time required by the Supreme Court. And now we'll be adding to each court case a certain number of hours to establish the amount of reparation. And is that a part of something that you looked at when you decided it was acceptable to go ahead with this bill?
To take that question, if that's okay, thank you.
Thank you. It's to answer your question. We haven't evaluated the specific amount of time that would be added. It is there could be situations where there would need to be evidence that was added for those points. The intention is that it's generally in restitution supposed to be very easily quantifiable expenses and not ones where the court needs to untangle, for example, a complex commercial transaction or that kind of thing. So we haven't done that assessment specifically, but it is possible that evidence would need to be heard.
OK. Et Madame Lapointe, j'aimerais savoir, est-ce que vous avez en tête des exemples?
And Ms. Lapointe, I'd like to know, do you have in mind some concrete examples concerning what you told us a few minutes ago at the fact about the restitution that might be accorded to the victims? Have victims spoken about this, and how long did it take to have these hearings? The bill is not based on a specific case, but it's the idea that the services that would be included in this bill, these are services that were recommended by the agencies that offer supports. Thank you. So these compensatory...
C'est fini. Excusez-moi, votre time is fini. My apologies. So moving on to Mr. Gill for 5 minutes. Please go ahead, sir.
Thank you, Madam Chair. And thanks to all of you. MP Lapointe, do you think most drug dealers have the money to pay a restitution order?
As I stated before, restitution orders exist today. Judges provide restitution orders to victims of crimes. And so it would very much be at the purview of the judge that's presiding over the case in determining the ability to pay. But I will tell you that whether or not the degree of enforceability is strong or not, restitution orders, and we know are not always collected, but we don't abandon restitution orders. And I think what we need to do is strengthen them. And so that is what this bill aims to do. Again, by providing some definitions to the judge, we are providing that judge with some tools for them to be able to explore that avenue if it's appropriate within that case and within that criminal that stands before them.
Prosecutors drop half of the cases in Canada. Everyday serious crimes against the person get dropped because we don't have enough Crown lawyers or courtrooms. Will an influx of financial hearing in drug cases add an extra burden to the court system?
I'm not sure I understand the question. I'm sorry.
I can repeat it for you. So prosecutors drop half of cases in Canada. Everyday serious crimes against the person get dropped because we don't have enough Crown lawyers or courtrooms. Will an influx of financial hearings in drug cases and add an extra burden to the court system?
Again, restitution orders already exist within the judicial system. They are there. Judges deal with restitution orders within their courts on a regular basis. This doesn't add a bureaucracy. This doesn't add to a caseload. It simply adds definitions for a judge when making a decision on restitution within their courts and within the case that appears before them.
Do you think community organizations have the time and resources to produce readily ascertainable expense reports? Do they have the time and resources to go to the court?
I'm glad you asked that question because I know that was a concern that was raised when we had the debate in the chamber. So I actually went back and did some further consultations with agencies. And what they told us was that because most of their funding come from either federal, provincial, municipal grants, they have to keep track of all of those costs when they submit at the end of the funding period. So they felt that there wasn't an additional burden, that all of those costs, those expenses have to be kept in order for them to continue receiving grants and funding.
So where do most drugs enter Canada from? Are we going to go after citizens of the country for restitution order?
So
I will repeat my question. Where do most drugs enter Canada from? Are we going to go after citizens of that country for restitution order? Is that all feasible in current climate?
So I'm not here to talk about police enforcement or police strategies. I can tell you that I did meet with the Chief of Police of Sudbury, who told me that the private members bill was discussed and dealt with at the Ontario Chief of Police Association, and they endorsed the bill and felt that it was a very worthy step in terms of accountability towards the crimes and the criminals committing those crimes.
Another question is, you used to work with David Lemaitre. David Lemaitre referred to drug dealers as single mothers trying to put food on the table. Is your view different?
Again, this bill is very much targeted towards making criminals accountable for the crimes that they commit, but also for the harm that those crimes have on victims as well as communities and the organizations that are providing services to those victims of the crimes.
I do have
15 seconds left.
Okay, then I'll.
Thank you very much. Moving on, Ms. Latanzio, please go ahead for 5 minutes.
Thank you, Madam Chair, and thank you, MP Lapointe, for your private member's bill. Congratulations, actually. My questions are going to be directed to the officials. So why is it important that restitution orders be based on losses that can be quantified and supported by evidence before the courts?
Thank you very much for the question. We've talked about a little bit today. These orders are really rooted in the sentencing process, and so that informs those considerations. They need to be. It's also because the courts have been very clear that these orders are not intended to take over the role of the civil courts, and criminal courts are not the right place, frankly, to be untangling complex transactions or determining complex questions of fault. So it really is because of how related to the sentencing process they are.
And can organizations that face significant costs when supporting victims of crime and responding to the impacts of this criminal activity in their communities?
If I understand the question, it is currently possible for organizations to receive restitution orders if they do fall under the types of expenses that are contemplated in Section 738, for example.
And how would this make it fairer?
So I won't speak to the fairer part, but what I'll say, this bill on my reading, the part about it that is novel is not the fact that organizations can receive the orders. What it does that's different is it allows organizations to be paid for new types of expenses related to certain offenses for drug and human trafficking. So in that sense, the general provisions in Section 738 aren't really written to address expenses where someone is paying an expense to help someone else as a result of a crime. So that's where this bill is doing something different.
And when Parliament creates this new restitution mechanism, what are some of the key legal and operational considerations that one must take into account?
Thank you for the question. The courts have been clear previously about the role of restitution and the importance of restitution in the sentencing process. And so some of those types of important considerations will be, can these expenses be easily proven? For example, are they readily ascertainable? Are they likely to be connected to specific offenders? All of those things would be important considerations.
And would it be fair to say that any restitution framework must strike a balance between supporting those affected by crime while also remaining in a workable state for courts to administer?
I think it's a fair statement. If there's a framework that's not workable for a court to administer, it's unlikely to be used by the court. So I think it's a fair statement.
Okay. And can you speak to the importance of ensuring the criminal code provisions are applied consistently across the different forms of victimization, including trafficking, sexual violence, intimate partner violence, and criminal harassment?
Yes, thank you for the question. When we're in the process of designing a policy, one of the key questions that we ask is, what's the intent of the policy? And in that respect, if as I understand from the preamble of this bill, it's designed to address drug and human trafficking and their impacts on communities. It's always a useful question to ask if there are related types of offending. Is that something also worth looking at? So I think it's a good question and a fair consideration for the committee.
With regards to the element of judicial discretion, why is it so important? Why is it such an important factor in the restitution orders or in this P&B?
Restitution orders play a very important role in the sentencing process. They can achieve a lot of the objectives of sentencing. And sentencing is an individualized exercise that courts undertake. So in that respect, it's important to answer your question. Judges are conducting individual assessments that depend quite a lot on the facts of the case. So it's a very important consideration for that reason.
And from a criminal law perspective, what challenges can arise when attempting to distinguish between direct losses caused by an offense and broader social costs associated with crime?
I would add briefly that the criminal process comes into play after a crime has been committed when we're talking about sentencing. And if we're talking about broader social costs of crime, many of those expenses can be seen in many different areas of society. And if we're talking about, for example, I note that one of the expenses listed in this bill is related to harm reduction programs. Some of those costs that organizations bear sometimes are at different stages of that process. When we're talking about criminal sentencing, we're talking about after a crime has already happened.
Thank you. Thank you very much. Mr. Babber, you've got 5 minutes. Please go ahead.
Thank you. I do have a couple of questions for the officials, but before I do, if I may please address Madame Lapointe very briefly. And I really want to put politics aside. I do thank you for bringing this bill forward. About 20 years ago, my last year of law school, I was a supervisor at a community legal aid clinic, and I dealt with very many organizations, the type of organizations that you contemplate. However, I do have to say that I take exception to the fact that you propose to provide restitution for organizations that actually perpetuate crime in the community, that contribute to crime in the community. And I kindly ask that you perhaps consider or reconsider those at amendment stage. To the officials, Ms. Wells, I understand that less than 2% of cases actually enjoy restitution orders as of the last couple of years on average. Am I in the ballpark?
Thank you for that question. So the data that the department uses is from Statistics Canada, and we commissioned it in 2025. So our numbers are slightly different than the numbers that we've been hearing throughout the debate. So I will just put those on the record. What we know is generally restitution is ordered in between 4 and 5% of all cases. But for cases where restitution might be more appropriate, such as property crimes, those numbers increase significantly. And what we know from the StatsCan data is that for fraud and mischief in particular, restitution can be ordered in approximately 28% of cases.
What is the percentage of collections on those restitution orders?
That's a very different situation. We know, so to be clear, enforcement of restitution orders falls to the provinces. It's under their jurisdiction for property and civil rights and outside of the criminal and the federal sphere of influence. So I don't have data on the number that are collected, but we know that it's lower than those that are issued, and it is a challenge. And it's
23, it was 0.5%.
It is very low, and it's something that the department is seized with. And
part of the concern that I have is that while we're all very well intentioned, in practicality, there is no collection. And I want to move on to Mr. Godleski, just to think about civil law a little bit in the context of restitution orders. Who would be enforcing a restitution order? Would it be the province? Would it be the beneficiary of the order?
It's a very good question. There are different types of restitution that can be ordered in the code, so the answer can depend on which type we're talking about. If we're talking about Section 738, the code provides that it's enforceable as a civil judgment if it's unpaid. So there are different provinces. The provinces are responsible for the enforcement, but ultimately, if the order is not enforced, it falls to civil enforcement. There are some provinces that have programs to help victims.
The focus is here is drug offenses, and so presumably we're talking about trying to enforce and collect from individuals that are busy with the drug trade. Something that I doubt would often happen. I'm curious because we're in a federal jurisdiction after all. Do restitution orders survive bankruptcy?
They do.
In other words, if a convict was ordered to pay restitution and they declare bankruptcy, and I mean that in the technical term of bankruptcy assignment, a restitution order survives? I'm not sure you're correct.
My
question is, sexual offenses resulting in a tort judgment survive. Obviously, fraud survives, but I'm not sure that a general criminal offense survives. Even the associate vice chair of the conservative vice chair thought that they don't even survive a proposal, even though a proposal would reduce such a debt. This is an interesting question for.
So our understanding of the case law, including from the Supreme Court, on the issue of restitution is that restitution orders do survive a bankruptcy declaration. Whether or not they are enforced and paid post-bankruptcy is not something we can speak to, but legally they do survive.
How long do I have?
So
Okay,
I think
well, thank you very much, Mr. Gulaski. Unless Mr. Gulaski has an answer.
Help that we just
No, I
found.
appreciate that. Thank you.
Okay.
thank you very much. Now moving on to Ms. Dolly Begum for 5 minutes. Please go ahead. You will have to open your camera, Ms. There you are.
Can you hear me? Oh.
Can you lower your boom, please? Your boom, your microphone. The little stick that comes out of your... yeah, there you go. Thank you.
Can you hear me now? Thank you very much. Thank you very much, Chair. Congratulations on your appointment. And I also want to thank MP Maloney for his time as well for the 6 months. I think he did a fabulous job. And now moving on to the PMB that we are here to speak to. And I just wanted to actually, I know we're short for time, but I wanted to first give Ms. Lapointe, well, first congratulate her on bringing this bill forward. And I know you've done a lot of consultation and worked with a lot of organizations. And just listening to the conversation reminded me of my time working with Victim Services Toronto and the work that they do to support so many families, so many victims throughout the process as they go through the system, the justice system as well. So I wanted to first ask if you could kind of take us back and talk about really what problem you were actually seeking to address when you first started, when you conceived this bill, and what made you bring this forward, and if you could speak to it a little bit.
Through you, Madam Chair, and thank you for the question. At its core, this bill is simple, but it really, I think, is about fairness. You have community organizations on very limited budgets that are providing essential services to the victims of these crimes. And at the same time, those who profit from these crimes aren't held accountable. And they aren't held accountable for the crimes and also for the harm that those crimes create, both for the victims and for the communities and for the organizations that provide services. And so it's about being, and whether this is police or paramedics or our healthcare system, emergency workers, as well as mental health and addictions, shelters. I can list, there's a long list of those community organizations that provide those really important services. So, and I remember I talked to one victim of human trafficking, and she said, the funding ends, but the trauma does not. And she was a really strong advocate for the restitution orders and the need to support those community organizations that have supported her through her journey.
You're on mute, Dolly.
Sorry, after all these years, you'd think that you would forget to. Thank you so much for that, Ms. Lapointe. One of the things I've come across working with a lot of women who find themselves in a loop working with different organizations who don't have the resources. And you mentioned frontline services. Many Canadians may not realize the role that these organizations play when or after a crime occurs. Can you speak to the types of services that they provide to victims and the communities? And you talked a little bit about the interview that you had with organizations, but I wanted to ask if you could describe a little bit about the types of services they provide.
So there's a wide range of services they provide, from a very immediate life-saving interventions that they may do to people who are suffering from addictions, to providing shelter and supports to the victims of those crimes. There's also a lot of counseling and support services as they transition and move through their journey. Many of the people end up being either at risk or homeless, and so providing support to the people living in unhoused conditions is something that we see. And so there are many services across a continuum of care. There's also emergency departments and also services within the mental health and addictions services that we see. So they are all there. They all step up, and honestly, I think they also keep our community together as they provide these services to the victims of these crimes.
Absolutely.
Thank you very much. That concludes your time, Ms. Begum. Et finalement, Monsieur Fortin, for...
Finally, Mr. Fortin, for 2.5 minutes, please. Thank you, Madam Chair. So, quickly, I will ask our officials. Earlier, I was asking about how long it would take to hear those issues, which lengthen how long it takes to go through the court process. But something else I didn't, Gary, it's the issue of jurisdiction. We know that Section 738 of the Criminal Code, which talks about indemnization or redress, goes beyond the constitutional law of 1867. So that's just my opinion. As far as I know, the Supreme Court has not yet stated its opinion on the jurisdictional value of 738. But now we're stretching the application of 738. So did you validate that? Is it not more that of jurisdiction for civil tribunals, provincial ones?
The provision in the case of Zelensky, where the Supreme Court has considered the validity of a restitution order from a constitutional perspective. We haven't. Yes. Yeah, we haven't conducted an assessment. It's on an earlier version of the section than this one, but we haven't conducted an assessment specifically on this bill. But
est-ce que c'est possible de nous envoyer au comité la...
Could you send to the committee the details of the Supreme Court's decision on the jurisdictional aspect, saying that Section 738 of the Criminal Code is in the jurisdiction of the federal legislator? I'll let you continue. So that was my answer? No, I thought I'd interrupted you. I'm sorry. But there's always a bit of delay with the translation. And I was asking you, how will we align that when we'll see that there'll be decisions where there's the issue of the surcharges. There's also the indemnization under the charter and also finding that the accused is guilty. How will that be done if the detainee does not have the funds necessary to pay the surcharge and indemnization to the victim and indemnization to the organization? How can that all be aligned?
It's a good question. Ultimately, it will come down to a judge in an individual case. I'd note, for example, that the victim surcharge functions a little bit differently than the restitution provision. It serves a little bit of a different purpose in that it's providing general funding for victim services as opposed to specific reparation for someone who's injured. So it's a valid consideration, and it would be a judge in an individual case who would determine which structure of those provisions would best meet the objectives of sentencing for that offender.
Thank you. Thank you very much. You got almost an extra minute there, Monsieur Fortin.
You're a wonderful chair, Mrs. Khalid. Thanks.
I want to say thank you very much to our witnesses. Thank you, Madame Lapointe, for your bill and for giving us the time to come in today. Thank you to our officials. We appreciate that. Before we adjourn today, we have a quick motion for approval of our budget for Bill C-238. All in favor? It has been circulated. Yes? All right. Awesome. All right. Thank you. Meeting adjourned.